See everybody, please sign in to your devices and then please take the roll. Well, first I have to take care of some business. Today is Tuesday, March 17th, 2026. I hereby call the Elections and Campaign Finance Subcommittee to order. Clerk, please open the roll. Please, members, please vote if you're present. Do not vote if you're not. Clerk, please take the, just a minute. I can't hear you. Madam Clerk, please take the vote. Oh, hold it. We got one still signing in here. I'm sorry.
Thank you.
Jen? All right, please take the vote.
Mr. Chairman, you have 6 members present. You have a quorum.
Thank you. Let's see. Do any members have any personal orders or announcements before we begin? Seeing none, today we have 7 bills on the calendar. And to the sadness of the members, we have a few that's been taken off notice. First is item number 1, HB 2036 by Representative Garrett has been taken off notice. And let's see. Next up is item number 2, HB 2568 by Representative Kumar.
Motion.
Have a motion and second. You have any amendments?
No, sir.
Okay. Tell us about your bill.
Thank you, Mr. Chairman. In the 2024 local elections for city council in our small town of Cross Plains, Tennessee, a poll worker by mistake allowed certain voters who did not live in the city boundaries to vote, while she allowed some people whose address was Cross Plains, but they lived outside to vote. And the losing candidate reported the matter in about 2 days to the local election commission, who investigated and found that, yes, irregularities had occurred. However, the losing candidate had no option except to go to court, Chancery Court, and challenge the election. The election was certified despite the fact that irregularities had been recognized. In a small town, it is uncomfortable to go and file a lawsuit against people. Yes, you ran against them, but they happen to be your neighbors too. And this legislation is drawn to resolve this problem so that courts are not the only avenue of resolving an irregularity in a small election. This act applies to local, county, and municipal elections only. It requires that when an irregularity is reported and confirmed by the local county election commission, the election will not be certified. The matter will be reported to the state election commission after investigation by the local commission, and the validity of the complaint will be evaluated. If the irregularity is found to be correct, the state election commission may order a special election. On the other hand, if the irregularity is not confirmed or found to be minor as to not have affected the election results, they will allow the election to stand. With that, I can answer any further questions.
Members? I guess seeing none, the question I have is, all right, the main reason it seems like you're wanting to empower the county election commission to recall an election, to order a new election, is because possibly there's favorites that's been called in the current election? Yes, Mr.
No, what we're trying to do is that an irregularity occurred, it is reported by the candidate, the local election commission confirms it. They tell the local candidate who feels that the election was unfairly called, the only option he has is to go to Chancery Court to challenge it. That's expensive, and a person does not really want to, again, file a lawsuit against people that are, virtually their neighbors. So in this situation, after the local county commission has confirmed the irregularity, they will refer it to the state election commission, bypassing the courts or leaving the courts out of it because of the expense involved. The state election commission will evaluate the situation and give a ruling whether a new election is needed or not.
Does your bill address what type of irregularities would be grounds for them sending it to the state election commission?
No, we have not listed, but irregularity will be people who are not qualified to vote, voted in the election.
Okay.
Or certain people who were qualified to vote who were not allowed to vote in the election.
Well, what about like the county election commission has the authority now to kick people off? They can file a preliminary, provisional ballot, and then that can be checked and kicked out. If they're not following that, isn't the county election commission not doing its job? Go ahead.
I'm not aware how the county election commission would be involved in it.
Oh, Representative Boone.
Thank you, Mr. Chairman. I believe we had an occurrence of this last cycle. We had a member say there were a large number of crossover votes in the primary. And the SEC was the body that heard the appeal and voted. I think there were 14 of 43 voted that there was a problem. Are you aware of that occurrence?
Go
No.
ahead.
No, I was not.
This is only about municipal. Is this just about municipal elections only?
Okay, my apologies, Mr. Chairman.
Yes, Representative Brecken.
Thank you, Mr. Chairman. And to the sponsor, of course, I assume the current protesting protocol has been in place for years and years, if not decades upon decades. And I'm reluctant to modify it. I hear your argument, especially in small communities. Now, the question I might have is that if the election commission feels like there might have been an error in some of the voting registrations or the balloting, could they not take it to Chancery Court and not the candidate?
Go ahead.
I was told that they could not. It is the candidate who has to sue the other candidates in the field, as well as the county election commission. They have to file the suit. And again, it's a matter of the expense involved, as well as the hesitation to sue fellow citizens.
I understand that. It's just tough to modify statutes that seemingly must be in place and working for the decades upon decades. So anyway, that's kind of.
Representative Kumar.
It is also, there's something not right about a statute where an irregularity occurs, a candidate reports it, the county commission agrees with it, but they say, sorry, we do have to certify the election. If it is admitted that an irregularity did occur in this election, why should it be certified? But that is the law. So, sometimes things need correction.
I guess I'm still trying to wrap my head around, rather than give unprecedented power to the state election commission and really the county, because they have to send it to the state election commission. Why wasn't the problem solved at the county when they could have thrown the ballots out? If they're the ones that are allowing the ballots, why would they then send it to the state election commission?
They consulted with the state election commission, and state election commission and the director were very, very aware of it. And yet it was that the election commission does not have recourse anything except to certify the election. It is only up to the losing candidate to file a lawsuit.
I guess the thing that really I'm trying to get at that concerns me is that it would appear that somebody either didn't do their job at the local level or were playing favorites, because the votes from out of the city that were allowed to vote should never have been allowed to vote or should have been kicked out by certification. And it should never have been certified with those votes counting. Mr. Chairman.
The irregularities, sir, was discovered 2 to 3 days later, and it became uncertain. So they discovered that some people who were qualified to vote were not allowed to vote, and some people who were not qualified to vote were allowed to vote. And then it became a question, are there other people that we are not aware of? You know, a few people reported, but others, there may be more.
Well, another thing is I think we have to establish, and somewhere, and if your bill's not doing it, we need, if we hadn't agreed to do this, the state election commission would need guidelines on what warranted being eligible to vote and not vote for them to even make a decision. And it's kind of given, I've never heard of them giving a power. I don't know the exact what happened. I remember some things in the news. We might, if any members are concerned, we could call up Director Goins and maybe he can inform us on what's going on if anybody wants to do that. We'll go out of commission with no objections. Out of session, excuse me. I said out of commission. I feel like I'm out of commission today. We're out of session.
Representative Kumar has explained the bill and the process very well. I'm here, Mark Goins, coordinator of elections. I'll answer any questions you have.
Oh, need to tell us who you are and,
Mark Goins, coordinator of elections
okay.
for Tennessee.
Yep, Representative Burkett.
Mr. Goins, just curiously, in the last number of years, do you know how many local city and county elections have garnered enough protest for the candidate to take it to Chancery Court?
I do not. They've been rare. I mean, in 17 years, we've had some. There's just not been that many that I'm aware of. But we've had some.
And the follow-up, if I could.
Go ahead.
The chairman's questions, if you've looked into it and talked to the bill sponsor, do you think there was a failure at the local election workers or somewhere there that caused this issue?
Yes. And Chairman Kumar and I have had multiple conversations since this happened. He definitely was representing his district in that city. That's exactly what happened. There was a precinct that had non-city voters in it, but unfortunately, some of those voters were given a city ballot, even though they were not eligible to vote in that. It is true what he stated that the election commission in that circumstance still certifies because you're certifying the totals, and that's what's contested. The totals are what's going to be contested for the lawsuit. So the election commission, in fact, there's penalties if the election commission does not certify. So that is actually under current law what kicks in the contest period. The moment that they certify, that gives the candidate standing or a live issue, case or controversy to sue.
Representative Burkett.
I'll say if a candidate does protest and does go to Chancery Court, does that stop the election commission from certifying the election?
No, normally it's certified to get them into Chancery Court, meaning that is the basis. You normally don't sue before it's certified. Once it's certified, that is what actually would give the person who's challenging the election the opportunity to have a court hear it. If it's not certified, there's really not much to challenge at that point. And I think that's why current law, and this is longstanding law. This has been the law probably since 1972, but maybe even beyond. But there's no, if we never certify the election, then, I don't know who's going to serve in that seat. And there's nothing really to challenge. I guess the lawsuit then would be to force us to certify the election. But without certification, it's very difficult for someone to contest the election. And that's why the statute's written the way that it is.
Vice Chairman Wright.
Thank you, Mr. Chairman. So I've sort of got a two-part question then. The election is going to be certified by the election commission. What is the election commission composed of?
It's majority and minority party, 3 members of the majority, 2 members of the minority. And majority is defined at whoever has the most members of the General Assembly. And that can change. In 2008, the Democrats had the majority in the General Assembly, House and Senate, and it was 3-2. 2009, after the 2008 election, the Republicans took majority in both, and that switched the election commissions.
Okay, so the problem I'm going to have then with the legislations before us is that we're saying there is a certifying party, and if the whatever we've got before us is going to be objected to, it's going to be decided by a partisan body which made the certification. So it's certification here, and we're going to make a decision by 3 and 2 to then come back and either uphold that or not. So even though it's expensive to go to court, I think we're still going to have to go to court. Thank you, Mr. Chairman.
Representative Powell.
Are you, Director, are you aware of any where we've had to have a whole new election, and elections completely thrown out in our recent history?
Ophelia Ford, that election was voided several years ago. We had a situation where a road superintendent sheriff? A sheriff candidate, it was determined he was not qualified after the 1 week left in early voting. So Post had certified someone, they got aware of some additional information. So it's not a result issue. It was a qualifying issue. And so the gentleman was ruled to not be qualified after the election, and the court did come in and rule. I think they had another election in that situation. I don't think they declared the person that came in second.
In the Ophelia Ford situation?
The Ophelia Ford was a scenario where she won a very close election. 2007 or 2000, I wasn't here, but unfortunately there were some ineligible people that had voted in that election. And so that went actually to the Senate, because the General Assembly determines the qualifications of its members, and the members, I believe, ordered another election.
Okay. Well, no.
I was not here, but that's my recollection.
Okay.
So I might be a little off on the facts.
One other question. The scenario was presented to us. There was actually, this wasn't the only election on the ballot, correct? There were a couple different elections.
That's correct.
So are you able to partly certify in a situation like this? Like let's say this was I don't know, good example, but let's say there's, sometimes we have municipal candidates in my city on the ballot at the same time federal candidates might be for whatever reason. Could you certify just the federal candidates and not, or would you have to, in that scenario, redo the entire election for even the election that didn't even apply to this?
Yeah, so not if this were to pass, it changes this process I'm about to explain. But under current law, in your scenario, the entire election will be certified. And if it's not under current law, then the person who is challenging the election could not get it in court. And once it's certified, that starts the clock for the individual to challenge that election. So it all is tied to that certification. If in this scenario, that election commission didn't certify the election, there's penalties that apply to that election commission. Because once again, they're certifying the totals. Those were the votes. Unfortunately, people in that city weren't eligible to vote, but that was the actual votes. And whether it would have changed the results or not, we really don't know. And the person who lost didn't know, because we don't know how they voted. But there was enough votes in that election to have made a difference.
Okay, and you also wouldn't know if there were drop-off voters, meaning they voted in one race but then didn't vote down ballot, correct? So you could have higher totals up ballot and then lesser down ballot.
That's a normal process for a city election, unless there's something that is going on in that city that drives out that's just typical. The further up you are on the ballot, then typically you're going to get more votes. You see that a lot with delegates, not necessarily with cities, but that can be the case, correct?
Okay, thank you.
Not always the case, though, because sometimes you have municipal folks who be very popular, So, I mean, but there's typically drop off.
All right. What about this? If depending on when regardless, I guess, whether it's held on its own or whether it's, if everything gets adapted with Sapicki's bill, whether it's held in August or November or in June, whatever the city election's held, especially if it's held at a time when the state's paying for it and they have to rehold this one election, is that going to be at the cost of the city or the state, or how would that be paid for?
So the general election, this applies to general election, not the primary. So I do not believe that this would impact the state funds that's going for reimbursement, because it does not impact primaries.
Now, what if if these people were allowed to vote out, say 100 people, and it was a close election, they were allowed to vote in the city election, they'd also be voting, if it's in August or November, they'd be voting in those local and state elections as well. Would all of them have to be reheld?
So that's, well, I mean, potentially. I mean, but I doubt it, because the ineligible votes would be in the city, and you have described exactly the process and how this got confused. If there's other races on the ballot, those folks are eligible to vote in that race. So you have all the voters coming in that precinct, only a certain amount of them was allowed to vote in the city election. But unfortunately, some of the other countywide voters were allowed to vote in the city, and they weren't supposed to. So it was exactly how I explained it. On election day, there was some poll officials who had been taught to make sure that people get in the right ballot. But unfortunately, at least part of the day, that was not what was occurring.
Okay. Any other questions before we go back into session? Seeing none, thank you. We'll go back into session. And that's session, not commission. Any other questions to the sponsor?
Question on the bill.
We have a question on the bill. Any objections to question on the bill? Closing. Representative Kumar.
Thank you. I just wanted to answer Vice Chair Wright's concern that the county commission is again appointed majority minority. So it's not impartial a body, and the Chancery Court might be, but it's not. They're also, these court judges also run on a political line ticket. And the fact that the County Election Commission, composed of 5 people in this situation, is partial. That's the very reason to move it to the State Commission. That's a larger body. And as I said, Chancery Court is also partial in that sense. These people have run on that way. The State Election Commission being a much larger body, it was felt that they will provide a better, broader decision than a body of 5 people with a 3-2 majority in a small community. And also there are personal, I know so-and-so, I'm related to so-and-so. So there are personal relationships involved too. So it's best to take it out of the county commission and move it to the state level. Okay. That was the feeling. And I want to thank Director Goins for working with me on it.
We had one more question, if we could hold up. Representative Wright, Vice Chairman, you had a question for the sponsor?
Yes, I was going to make, thank you, Mr. Chairman. I was going to make the comment that was my point. It may not be passed by the local election commission on up the hill because of the partisan makeup of the commission. That's my concern. Thank you, Mr. Chairman.
Go ahead.
I'm sorry, I didn't understand that. Kindly explain it to me again.
Go ahead.
Thank you, Mr. Chairman. My concern was that it will not get out of the county election commission.
And why would it not get out of the county commission?
Because they don't want it to.
I think the mechanism is very good. The director of elections in the county, when she takes it to the county commission, she at the same time did contact the director of elections, Director Goins, and they worked together to come up with the right decision, basically to define the fact, did an irregularity or irregularities occur? And if they did, then they admitted to that. But what's wrong with the current process and law is that the election will be certified. To most people and to the candidates, it's been certified, that means game over. And so the matter is never really completely resolved in a fair manner. And this will put it, number one, the election would not be certified. Number two, irregularity would be admitted. Number three, it will be referred to a larger body such as the State Commission. And the State Commission, I have spoken with them too. They were agreeable or pleased to take on this task.
I think one thing that from what, if I'm not mistaken, what Vice Chairman Wright is indicating is at the local level, it may not be the same condition as your county. It could be that the County Election Commission made a mistake in another county and they want to cover it up and they won't send it on to the state. They like the results just the way they were and they don't want to draw attention to it. So you never know what's going to happen in each county. You're kind of opening up a can of worms but it's still ultimately up to the county the County Election Commission that made the mistake, whether they want to expose it or cover it up.
In that sense, we should make a point of avoiding that happening. And the irregularity is reported to the Director of Elections in the state.
We have Chairman Howe.
Thank you, Mr. Chairman. And I respect what Chairman Kumar is attempting to do, but in listening to the debate and listening to testimony, this bill would really turn current law on its head. We heard testimony that in order to challenge, you have to have standing, and the only way you get standing is if they certify the election. And this would do just the opposite. You can challenge before it's certified, so there'd be no standing. So I think it's, I respect what he's trying to do. I really do. No one wants to have people voting who shouldn't be voting. But I think it needs more work, Chairman. I really do. And I think it might be good if you had another year to work on it.
May I
Mr. Sponsor.
ask the bill to be rolled a week, and I will work with fellow members, and we'll come with a neat amendment?
This is a final meeting.
Okay. Well, the people who are involved in this election, they would be very disappointed that we were not able to resolve it. I worked with, again, Director Goins, and we felt this was a reasonable solution. As I said, there's something wrong with the current law that we're going to admit an election to be irregular or irregularity having occurred, and then we are going to say that we will certify it. And people look upon that as a final action, and the law needs correction. Yeah.
We're back to the committee. Back to Mr. Bricken.
Question on bill.
Question on the bill. Seeing objections? Seeing none. Clerk, please open the board for voting. Members, please cast your vote. Please take the vote.
Mr. Chairman, you have 1 aye and 6 noes.
Bill fails. Please work on it again. Maybe we'll work out something. Next up is item number 3, HB 2613 by Chairman Halsey. Let's see, do I hear a motion second on the bill? I have a motion second on the bill. And I believe you have an amendment that
Yes,
makes the
sir.
bill? What
Mr.
drafting
Chairman,
code?
I certainly do, and thank you. It's Amendment 014561.
That's what we have. To hear a motion and second on the amendment. Hear a motion second on the amendment. Please tell us, you want the amendment on the bill or?
Please, sir.
If no objections, we'll put the motion on the, put the amendment on the bill. All those in favor say aye. Aye, opposed nay. It goes on the bill.
Thank you, sir.
Please tell us about your amended bill.
Okay. Thank you, committee, and thank you, Chairman. I hope we're in a roll with them red lights up there on that board. Well, this bill.
You hope we are or not?
No, I hope we're going to change the course here.
Okay.
The bill would require candidates for state and federal office to submit documentary proof of eligibility. And that documentation will be verified by the Secretary of State and State Election Commission and county election boards. A lot of this stuff's already in law. And so I'm doing what we do down here. Sometimes we pass bills that say we're passing a law that says we're going to obey the law. Some of that's in here, but part of that that's different is this deals with the president and in particular, the president of the United States, the vice president of the United States, to demonstrate that they are natural born citizens and what that means and where it came from. And that they meet the constitutional age requirement and have resided in the United States for the constitutionally required period before appearing on the ballot. It says presidential electors would be prohibited from voting for candidates whose eligibility remains unresolved. The bill would also require that electors not hold federal office. Congressional offices for candidates for the U.S. Senate and U.S. House of Representatives, the bill would require proof of age, U.S. citizenship, and state residency. And then one more thing, the bill would require political parties to vet their candidates and submit proof of eligibility, which you've discussed some of that already today.
Now, I don't know if it's yours, we have a witness.
I do, sir.
We want to go out of session and hear the witness from Mr. J.B. Williams. He is here. Any objections? We'll go out of session. Hear from witness. Please be seated. Tell us your name and where you're from, and we'll cut the mics on. You have 3 minutes.
Thank you. I'll take my hat off. That's due to cold, not due to style. Although, and some of us can relate, I'm sure. First off,
I'm getting there.
Thank you to the whole committee and Mr. Chairman for allowing me to speak here on this bill today. I appreciate it very much. I think this is a very important bill, not only for Tennessee, but actually for the country.
Tell us your name.
My name is J.B. Williams.
Okay.
I live in Murfreesboro, Tennessee. I've been a Tennessean for about 33 years, so more than half of my adult life. And I love this state and I love this country, and I want to do what I can to promote a circumstance where more and more, hopefully a majority of American voters eventually regain trust in our electoral systems. It's been interesting hearing some of the testimony on the other bills today. It seems like election eligibility is a big topic right now. This particular bill pertains to candidate eligibility, not voter eligibility. And the reason for it, this is a bill that myself and others at North American Law Center drafted 4 years ago, actually. It was sent to your folks here in the legislature 3 years ago, introduced last year by Frank Nicely and Bud Halsley, and somebody in the social media realm torpedoed it and it was withdrawn. And so we're back here again this year. The issue is, and this is not a partisan issue, I want to state for the record. In the past, it's our opinion, researched opinion, that at least seven different candidates have appeared on ballots across this country who did not meet the natural born citizen eligibility requirement. 2 of which made it all the way to the White House. 5 of them were Republican, 2 were Democrat. This is not about partisanship. This is about constitutionality of the most powerful political office anywhere in the world, and the ability of the American people to trust that people seeking this office have the legal eligibility to seek the office. Now, the issue really seems to come down to what is and what is not a natural born citizen. And opinions vary about that. And it varies for a number of reasons, some of which are, I think, legitimate misunderstandings, and other ones I think are probably purposeful as it relates to political agendas. Either way, there is an original purpose, intent, and understanding of what's in our charters of freedom. And in this instance, the natural born citizen requirement is found in Article 2 of the U.S. Constitution, and it says none other than a natural born citizen is eligible to hold the office, correct? The question is, what does it mean? Where does it come from? What does natural born citizen mean? I'm going to make this in a way that voters understand. A natural born citizen is not a British common law term. It's a natural law term. If you refer to the opening preamble in the Declaration of Independence, it states that everything that our founders were framing at the time was based on the laws of nature and nature's God. What's meant by that is the laws of nature are things that exist in nature. Natural born citizen exists in nature. Let me stop for. I'm sorry.
Thank you, Mr. Chairman. Thank you for being here. Could you finish your definition of natural-born citizen for the committee, please?
I'd be happy to. And I want to state for the record, this is not my definition. This is a definition of the framers, of the founders themselves. The natural born citizen clause was placed in Article 2 by founder John Jay. John Jay explained why he wanted to add it to Article 2. It was very simple. It was to prevent foreign occupation of the People's White House, plain and simple. Foreign intrusion, foreign dual divided, unknown loyalties to foreign countries. That was the purpose of it. Natural born citizen, to finish my thought earlier, if I explain it, the way I would in giving a speech to somebody full, a room full of citizens or voters, I say quite simply, a natural born citizen is the natural offspring of American citizens. Period. That's it. It really doesn't matter where they're born. It doesn't matter whether they're Christian or Muslim or Jewish or agnostic or none of that. It's simply the offspring, the natural offspring of American citizens. The natural born citizenship is therefore inherited from the parentage. It's a bloodline. It's a matter of the bloodline. Now, there's a lot of confusion in recent years comes from what I consider to be, or what we consider on research to be, misinterpretations of the 14th Amendment, where it talks about the right to citizenship under the 14th. I want to note in that regard that there's no mention in the 14th of birthrights, and there's also no mention of natural born citizen. There's a reason for that. The 14th is part of the Reconstruction Amendments. The 13th is what gave permanent freedom to the slaves. The 14th gave them citizenship, a right to citizenship legally, and the 15th gave them voting rights. So the 14th sits right between the other two. Those three documents were not really ever intended for anybody other than that at the time, but it's been used for a lot of other things since then. In addition to that, we have had an issue in recent years where we have inordinate amount of illegal migration into the country. And so because of all that, who can vote and who can't, who can run and who can't, these things have become front burner issues because of failures we've had in other areas in the country to protect our sovereignty and our security as a country. I'll stop there, open it up for any other questions.
Any other questions while we're out? Oh, follow up.
Yeah, if I could just pursue that. So if I understood your definition, a natural born citizen would be an offspring of an American citizen. So I'm thinking of situations that I know of now in elected government where the parents may have been born in another country, but they moved here and then they had children in the United States.
So
how does that qualify?
Okay, so the deciding factor in that regard wouldn't be where the parents were born prior to moving or any of that. It would be, did they naturalize after they got here and became legal U.S. citizens prior to the birth of the child?
Okay. Thank you, Mr. Chairman.
Thank you. So you referenced 7 presidents that you,
7 candidates.
7 candidates, and you said 2 presidents.
No, 1 president, 1 vice president.
Okay. Who are those president and vice presidents?
That would be Barack Obama and Kamala Harris. Barack Obama's, according to his bio, is the son of Barack Obama Sr. Barack Obama Sr. at no time in his life was a legal citizen of the United States. He was at all times a legal citizen of Kenya. So the theory is very simple in natural law. No one can pass to someone else something they do not possess. If you're not a citizen, you can't pass citizenship to your children. And I can look at this, I can ask the committee to look at this 2 ways. Imagine Osama bin Laden's grandchild having been born in the USA to a father who was at no time ever a member or a citizen of this country. That's the exact type of situation that the natural born citizen is trying to prevent from happening. I can flip it the other way. Let's say that you and your family or your kids and their are on vacation overseas, and happen to give birth to one of their children while they're, let's say, in France. The fact that they're born in France does not make them a French citizen because the parents are citizens of the United States. That child is a citizen of the United States merely because the parents are citizens of the United States. Doesn't matter where they're born. Now, there's what's called, and I want to make a distinction between treaty with a Y and treaties with a ISE. The law related to all this comes from natural law. Where the founders borrowed it from is from a treatise, ISE, by the title of the Law of Nations. That has been adopted pretty much by every country in the world and understood by every country in the world as it relates to citizenship. It's not an international law. It's a writing about international understandings, that the laws of nature are things that you cannot legislate in or out of existence. And I always use gravity as an example. If you don't like gravity, you can pass a piece of legislation against gravity, but gravity is still here. Same is true with natural born citizen.
Yeah,
Go
I
ahead.
guess just the thing I would say is, well, there's a lot there, but you said that voters had a misunderstanding. It was there was a lot of documentation about President Obama, and he legally qualified for the ballot. I'd also disagree with you and say that he was elected twice, popular vote. The voters elected him. You might not accept that, but that's the true reality. The other thing is, currently, if someone is born in the United States, currently, they are in fact a citizen of the United States. So under what this is proposing, someone that potentially is currently a citizen by birth of the United States would not be eligible to run.
Go ahead.
Go ahead.
So you're right. Under the current interpretation of the 14th, anyone born in the USA has a right to citizenship in the USA. Not all of them choose that, by the way. Maybe they were just visiting here and they're still citizens of their home country. But they have a right to citizenship under the 14th. But you're assuming, or this argument assumes, that citizen and natural born citizen are the same thing. There's nothing in the 14th that says that, number one, and it would need to if that's what it meant. Number two, if it was the same thing, there'd be no need to put a natural born citizen clause in Article 2, indicating that it's a special type of citizen that can occupy the White House. As it pertains to Barack Obama, yeah, he was elected twice. You're correct. Kamala Harris was elected once and then ran for president a second time. The reason this bill is here is because no one properly vetted on the basis of what natural born citizen means as to whether or not they should have been on the ballot. Now, the other 5, so you understand, the other 5 of the 7 were Republicans. This is not partisan. This is not about whether I like a politician or don't like a politician, voted for a politician or didn't vote for a politician. People can vote for things they shouldn't all the time. That's a freedom that we have in this country. The problem is, right now we're working to vet who can and cannot vote without vetting properly who can and cannot even run.
Where is it in the law or the Constitution where it states, which is current policy, current accepted law, or Supreme Court decision, where is it that has enabled that if you are the child, regardless if you're born overseas or in America, of an American citizen, like Obama's mother was an born American, where is it? It's accepted law or policy, especially it would either have to be, I guess it's been challenged in court, Supreme Court or something. Where is that decision, or what is that has enabled that?
I don't know that I brought that with me as far as being able to quote it, but I have provided it to the sponsors in the Talking Points memo. There was actually 4 cases at the Supreme Court where natural born citizen was referenced, and they used exactly the same point of origin that I do, the Law of Nations. The Law of Nations also, by the way, appears in Article 1 as an enumerated power of Congress to enforce the Law of Nations. It's in Article 1 as well. So there are 4 previous, maybe 5, if you want to stretch one a little bit. It wasn't really on that topic, but it did address what is and isn't a natural born citizen. There's 5 cases that are like that. They're in the Talking Points memo that Mr. Halsey has.
Okay. Any other questions while we're out of session? Mr. Leatherwood, also a man who has apparently been confused with Chairman Wright at times. That happened earlier today.
That is correct. At lunch, I told him it was an honor to be mistaken for you. Hopefully that won't hurt my credibility with anybody that I said that. But I was wondering, with this bill, does this increase or change the eligibility for any of these positions? And I'm thinking in particular, especially the congressional office. Will this change anything?
Go ahead.
Not that I'm aware of. The issue in this bill really has come down to what people think natural born citizen means. Well, that requirement only exists for president. It's president in Article 2, but the 12th Amendment applies all the requirements in Article 2 to the office of vice president for obvious reasons. Vice president is first in line to succession to the president. But those are the only two offices that this term applies to right now.
Go ahead, follow up.
Okay. And just wanted to confirm that because we did have other legislation that would apply the natural born citizen to the U.S. Congress or Senate. This does not change anything. It's just clarifying.
Correct. This one does not do that, but I understand there's other pieces that would recommend that or suggest that.
One last thing. In the portion dealing with political parties, I do have some concern with this, the consequences if a party runs a candidate, what does it say, who they should have known or reasonably known that the candidate wasn't really eligible. That might prevent them from having ballot access for the cycle, or they may be disqualified from presenting candidates in future elections.
Mm-hmm.
I do have some concerns with that. My assumption, and you can tell me what it is, that someone would take this to court and a court would decide. And I don't know that I always trust the court. So theoretically, a court could decide that one party or the other could not run a candidate because that court said they violated this law. That gives me some concern. Of course, it can be appealed. Hopefully by the time it gets to Supreme Court, it's figured out. But how many election cycles have gone by where one party or the other is denied ballot access? So that concerns me some, if you can address that.
Yeah, I understand. You know, it was kind of fortunate for me that I got to listen to the testimony to the bill prior, because most of that testimony revolved around trying to put the horse back in the barn after it was out and trampled all over the rose garden already. This is a bill that prevents the horse from getting out and trampling on the roses in the future. It has been out of the barn, it's trampled on the roses before. This bill is to prevent it from doing that in the future. And so, you know, it is very hard to put the genie back in the bottle once the genie's out. I think the objective of this particular piece of legislation is to keep the genie in the bottle so that we don't have to chase it around through the courts for the next, 10 years, working our way to the Supreme Court at great expense to try to put the genie back in the bottle once it's out. So I think this particular piece of legislation, it's simply an enforcement piece, as Mr. Halsey mentioned. It's an enforcement piece. We didn't add any new requirements in this bill for any of the offices, and we didn't add any new definitions of the bill. The definition, if you don't mind, I'd like to read where it comes from specifically. In the Law of Nations, it defines natural born citizen this way: as the society cannot exist and perpetuate itself otherwise than by the children of the citizens, those children naturally follow the condition of their fathers and succeed to all their rights. The country of the fathers is therefore that of the children. I say that in order to be of the country, it is necessary to be born of a person or a father who is a citizen. For if he's only born here as a foreigner, it will be only his place of birth and not his country. Now, that's exactly what the point of natural born citizen is. And that is exactly the terminology that the founders understood when they put it in Article 2. And it's also the one that's referenced in at least 4 or 5 different Supreme Court cases dating back to the 1800s, early 1900s.
Well, if there's no other questions, we have someone else. Any other questions? Thank you.
Thank you very
Appreciate
much.
you. Wealth of knowledge there. Ms. Hosey, we got one other person.
I'm sorry.
I had a question to Director Goins.
Mark Goins, Coordinator of Elections for State of Tennessee.
Thank you. I had a question, and I guess Mr. Hosey could answer it too, but I didn't want to make you have to get up twice, call out a session twice. I believe it's section 5 on item 4C. I've noticed in here, I was reading it, it says the political party may be prevented from seeking ballot access for any candidates for any office of election cycle involved. Is any, would that mean, what would that mean?
So if you read, so right above section 5, and there may,
And C?
no, right above section 5, state office means elected or appointed governmental office at the local and state levels. So this applies to elected and appointed positions. And then if you read where you are, state offices. So I went directly above state offices and I read the definition of state office that you just asked me to do. And then when it talks about what you're talking about, it means ballot access within the state. So this would apply to, it appears to me it would apply to, and there's another statute, there's another language in here that deals with federal officials as well. So it appears to me this would apply to appointed as well as elected officials who, so if you're running for office, that would be somebody that would be trying to get granted ballot access. The language is a little different in the Tennessee Constitution versus what the president, what it says for president. It does say natural born for president. For the Tennessee Constitution, for U.S. Senate, I mean, not for U.S. Senate, I'm sorry, for state Senate, state House, I think it's a citizen of Tennessee. I don't think I know. And then the governor, the same as well. So it doesn't say natural born, but you know, if the legislature defines natural born into that, then that would be something that we would, seek to enforce.
Any questions of the coordinator? I keep saying director, coordinator while we're out of session. Seeing none, thank you. We'll go back into session. Mr. Halsey, you're up.
Thank you, sir. I was just going to add one other thing. This is out of the laws of nations as well. It says it is asked whether the children born of citizens in a foreign country are citizens. The laws have decided this question in several countries, and the regulations must be followed. By the law of nature alone, children follow the condition of their fathers and enter into all their rights. So I'm not trying to stir anything up here. I'm just trying to be constitutional when it comes to putting a presidential candidate or a vice presidential candidate on the ballot in the state of Tennessee, that we do what the Constitution says.
Representative Powell.
Can I ask a question on legal?
I have quite a session. Want legal?
Yeah.
Any objections? Quite a session? Legal?
My question for legal is, does this, obviously under the supremacy clause, states can't add their own qualifications for federal office. Would this bill create a different qualification for federal office standard for our state?
Thank you. Josh Houston, Legal Services. My understanding of this bill is this does not add any qualifications to any office. It is simply requiring you to meet the eligibility requirements and then prove them beyond doubt.
So does it add different eligibility requirements?
Not as that I'm aware, no. The only thing that it does is require you to prove beyond a doubt that you are constitutionally eligible to hold that office. And so it does have that description of natural born citizen, but that would only apply in the case of the president, because that's the only office that is a requirement for.
And one other question, how would you define beyond a reasonable doubt, or how would that be interpreted?
It is not defined here, and it does not say beyond reasonable doubt. It says beyond any doubt.
Beyond any doubt?
That is what it says.
Wow.
Is that something beyond what courts require?
The criminal code does require only to be convicted of a crime. It is beyond any reasonable doubt.
What is the difference between any doubt versus reasonable doubt?
I assume that you could provide unreasonable doubt and that would suffice. I mean, it's something that's foreign to me. I've not heard of beyond a burden of proof of beyond any doubt. That's not typically something that you would see in a law.
Thank you.
All right. Any other questions for legal? Seeing none, we'll go back into session. Mr. Halsey.
I might add that I bounced this off the AG's office. They didn't have any problems with the interview except the natural born citizen. They had some questions about that. And they said, we looking at the constitutionality of it. And I said, well, how can you say that it's unconstitutional? Because the definition for it is not in the Constitution. It's just requirements in there. So I do want you to know that they vetted, the AG's office vetted all this, and they really didn't have an answer for the natural born citizen side.
Okay. Any other questions? Seeing none. Oh, Representative Howe, I thought you was just waving at me. I didn't know.
Hello, Chairman. Just for clarity, sometimes I'm a simple-minded man and I need to clarify things. Your bill does not change election law at all. It does not add any requirements at all.
No.
It simply says we're going to follow the Constitution.
And state law.
See, I understand that. Thank you.
All right. Any other questions? Oh, Vice Chairman Wright.
Thank you, Mr. Chairman. Sponsor, the ground that we plowed there a second ago about the reasonable doubt, beyond any doubt, gave me heartburn to begin with, but my heart's really on fire now. Beyond any doubt is going to be a high fence for me to jump, but really where I was headed toward the fence that's got me hung up, as a recovering county commissioner, if there's nothing really changing in what we're looking at right now on the bill, and then on the bill as amended, there's $1,200,000 at state level expense, $2,400,000 expense local government thereafter. So how are we running up a bill when we're not making any changes?
Mr. Chairman.
Oh, go ahead.
It's a great question. And the first part of your question is, I would just say, Representative Wright, you are my friend beyond any doubt.
You're my buddy.
That's pretty close. Second thing is, it's an interesting point you made. We're supposed to be doing this already. All these local committees are supposed to be doing this, state's supposed to be doing this, or we're supposed to be vetting these people all the time. Why now, if we're supposed to be doing it, is it going to cost X amount of money to start doing what we're supposed to be doing? So I've got to argue with fiscal review over that issue, but we are supposed to be doing that already.
Have any other questions? Seeing none, is everyone ready to vote? We are voting on the bill HB 2613 as amended. Please open the board for voting. Vote your wheel. Please take the vote.
Mr. Chairman, you have 4 ayes and 3 noes.
Bill passes on the state and local full.
Thank you, Mr. Chairman. Thank you, committee.
Let's see, next up, we have item number 4, HB 1921 by Miller. It has been taken off notice. Let's see, next up. We have item number 2238 by Hurt. It has been taken off notice by the request of the sponsor. Next up is item number 6, HB 1267 by Representative Johnson. We have a motion? And a second? We have a motion, second. And you have amendments?
I have an amendment that makes the bill.
All right, tell us that number.
5311.
5311. Okay, we have it. That's correct. I'll have a motion second on the amendment. Motion second on the amendment. You want to attach the amendment to the bill?
Yes.
Any objections to attaching amendment to the bill? All those in favor say aye. Opposed, say aye. Nay? Bill amendment fails.
Thank you, Chairman and Committee.
You still have a bill on the floor. Unamended bill on the floor?
Well, the amendment makes the bill, so that's pretty important. I have folks here to testify as well, but oh well.
Yep, Mr. Representative Powell.
Can we still hear from the witnesses?
Well, technically, the bill is still on, the unamended bill is still on the board, so.
We could always reconsider action.
We have a question on the bill and a second.
So they've been waiting all day to testify, but we're going to call the question.
All right. Well, I have a question on the bill. I can't really do anything. They don't want to, no one withdrawing, so it's a proper motion. I have a question on the bill. We'll be voting on the bill as is. HB 1267 by Johnson, as amended. We'll be voting. Please open the board. All those take your vote. Please take the vote.
Mr. Chairman, you have 1 aye and 6 noes.
Bill fails. And it is time to pass the gavel. So you did this? Okay.
I've got it here. Thank you, Mr. Chairman. Next bill on the agenda today is House Bill 1668. I have a motion. 1669. Let me rephrase that again. This is House Bill 1669.
Second.
Have a motion and second. Is there amendment on the bill?
Yes, it needs to be on the bill. It's the caption.
What's your amendment number?
It is 15306.
Have a motion and second on the amendment. Since the amendment makes the bill, all in favor say aye.
Aye.
Opposed, no. The amendment's attached to the bill. Chairman Rudd, you're recognized on your bill, House Bill 1669.
Thank you, Mr. Chairman. This is a cleanup bill by the Secretary of State and by Coordinator of Elections of, I believe, 4 different items. Section 1 establishes a reimbursement procedure in the years where the General Assembly provides funds for the May primary. This process will mirror the same system the Secretary of State already has in place for reimbursement of the presidential preference primary. Next, it would also prohibit private funding of election administrators. Right now, you can have some funding for certain conditions with the approval of the speakers. This would just outlaw private funding in our elections, period. Section 4, this is an update filing requirements in light of efficiencies created by the digital bookkeeping. We're getting high tech, so we have to change our rules. The county election commissions will still maintain hard copy paper records of registrations, but will not be required to store them alphabetically. If the county determines it would be more effective to store the records by date, that would be allowable so long as the paper record would be located when needed. And finally, hard copies purged would still be filed separately, but the reason for the purge would be stored in the voter's electronic record instead of having to be attached to the paper record. It's very cumbersome to have to attach all that to the actual papers. Any documentation regarding the purge record would have the same retention requirements under purge record rules now, and that is the bill.
Questions of the sponsor?
Question on the bill.
Have proper question on the bill. There be no objection. We're voting on House Bill 1669 as amended. Madam Clerk, open the board. All in favor, vote yes. Opposed, no. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Vice Chairman, you have 6 ayes and 1 no.
Bill passes on to state and local, full state and local government.
Thank you. And that concludes our business for the day. With that, I'll entertain a motion to adjourn. We are adjourned as soon as we have a motion to adjourn. I have a motion to adjourn, and we are closed. We are adjourned, closed to the subject of the call of the chair. Thank you.